go. All right, it's YouTube will be firing up. If one goes to the Fulton County Superior Court website, there's now a link for the live feed of matters, and you would go to Judge McBurney, click on his link, and you will see and hear everything we're doing for the next however long we're doing it. So that's an option for any clients or staff members who wanted to plug in but didn't want to be in the same room with any of you. That's been taken care of. So let me figure out who all we've got here. Ms. Williams is our court reporter. I'm the judge. I see Ms. Ward. You are co-counsel with Mr. Cochran on behalf of Dr. Randolph. Is that correct?
Correct.
Okay. You must be in room with someone else who's on. Okay, Mr. Blitch, it's good to see you. I didn't see your name on anything I was reading. Who do you represent?
Judge McBurney, I'm representing, along with Tony Cochran and Emily Ward, Dr. Randolph.
Great. I'll add your
name. An appearance on Monday.
Okay.
But
well, it has been raining pleadings on me in this case, so I didn't see that one, but doesn't mean you're not officially on board. The roster of Dr. Randolph's attorneys grows. I see Mr. Kruger, and I learned from Mr. Moldovan that you, Mr. Kruger, represent the 3 doctors who are the peer review panelists. Dr., and I apologize if I mispronounced them, Shakibnia, Adesunloye, and Hansra.
Yes, sir, that's correct. Thanks.
You represent all 3?
Yes, sir.
Okay. And there's Dr. Randolph, 1927. Someone's given away his year of birth. I guess that's Mr. Cochran.
Yes, sir.
All right. And then that next window, you see 1.5 attorneys in the screen. That's Mr. Moldovan and Mr. Schnell. They represent, as I understand it, both of the corporate defendants, the Cancer Treatment Centers of America in their 2 iterations, as well as Mr. Watkins. Is it Mr. or Dr. Watkins? Mr. Watkins, who is the CEO of what I'm going to call the hospital. I see Dr. Shakibnia. Did I pronounce your name okay?
Yeah, you got it right.
All right, A+. And then you'll see Ms. Niles's tile there. She usually is shy and doesn't get onto video. That's my staff attorney. So if I sound like I know anything about the case, you can thank her for that. But she's listening in so that we can get an order out post haste, because as I understand it, the main thing we're working through today, and I know there are a lot of moving parts and there's the whole rest of the lawsuit, but the main thing we're working through today in our limited time together is Dr. Randolph's motion for an interlocutory injunction that would have the effect of delaying, I think maybe it's now for the 5th time, the peer review hearing that is scheduled for the 22nd, which is this Friday, 2 days from now. There are some other things we'll talk about briefly, sealing the pleading that the 2 corporate defendants and Mr. Watkins filed. And I think there's some back and forth about whether Dr. Shakibnia could be called to testify. We can work through that as well. But the main focus is going to be this question of whether the hearing, the peer review group goes forward on the 22nd. So I've said a lot. I'm going to say a little bit more because I want you all to know what I understand to be going on right now so that you don't have to repeat things I got right, and so you can work hard on the things I got wrong. And that way we can have a more focused discussion. But as I understand it, Dr. Randolph joined the CTCA practice late last year, signed a contract, got a nice signing bonus and a pretty good annual salary. And according to some of the records I've seen, it went downhill pretty quickly in terms of his perceived performance. And he has in fact been terminated. So one of the things we're going to talk about is what's the harm of going forward with a peer review hearing if in fact Dr. Randolph has already been terminated from employment at CTCA. And I have lots to be educated on in terms of, well, if you lose clinical privileges, that affects your medical license, whereas being terminated doesn't. So you guys can give me the finer points on that. The concerns that were raised about Dr. Randolph's performance resulted in an interim suspension by a doctor who is not any of the doctors here, but was the supervising physician, or some title that suggested I think it was he, was in a position of authority. There was an investigative panel that was put together, 3 people, not the 3 doctors we're talking about now. They recommended that the suspension should be made permanent, but then the MEC, finding it peculiar that there were such plain examples of underperformance as contrasted with Dr. Randolph's application and the fact that he was hired and apparently seemed to be doing all the right things such that he got the job. There was a concern about maybe some underlying situation that might explain Dr. Randolph's performance. And so he was requested to get a particular evaluation. We've now had some filings back and forth about whether he got that, whether he got the thing he was supposed to get, et cetera. We can talk about it, but to me, that's not here nor there. It's relevant, but that's not going to drive the decision on whether the hearing goes forward on Friday or not. Ultimately, Dr. Randolph was terminated, meaning his contract, his employment contract was ended. There were many efforts made to have a peer review hearing. One of the doctors who was originally designated not by Mr. Watkins, although there seems to be a disagreement about that, but by the chief of staff instead. And I'm led to believe that, just by reading things, that the chief of staff is someone different from Mr. Watkins. But that the chief of staff originally appointed 3 doctors, one of whom had to be removed or asked to be removed from the panel because he had treated one of the patients Dr. Randolph had, and that created a possible conflict. So he was off, and Hansra or Addison Loye replaced that person. But it's been those 3 doctors since, and Dr. Randolph has asked on 3 or 4 occasions to have his hearing delayed. And every time the answer has been okay. In other words, accommodation. But it sounds like the defendants are ready to move forward with this long-awaited hearing. Dr. Randolph has alleged a number of irregularities with the process that he contends are inconsistent with the bylaws, and argues that he has a due process right to a hearing that complies with the bylaws. But of course, what he's seeking now is not a money judgment. He is seeking an interlocutory injunction, which has some pretty clear requirements. And that's what I'm going to try to focus us on, as to whether those requirements are met by what has been pled so far, or by evidence that may be presented during the time that we have together. So that's my thumbnail sketch of where I think we have gotten. And I'd like to start with one of the lawyers for Dr. Randolph to add or subtract to that, so we can agree we're starting from sort of the same factual or allegation basis.
I think that's fairly accurate, Your Honor. This is Tony Cochran on behalf of Dr. Randolph. The hearing.
Hold on one second, Mr. Cochran. Are you able to hear that? If you're muted, in other words, we can't hear you, you're welcome to turn your volume up. We'll see what happens with that. Okay. I'm sorry, Mr. Cochran, you were saying how right I was. I liked that.
No, I think in terms of the general background, you're correct, Your Honor. We have made it clear on behalf of Dr. Randolph from the outset that he is entitled to a fair hearing under Georgia law. I mean, we've got ample authority there on the St. Mary's case, the Madonna case.
So I don't want you to argue yet, Mr. Cochran.
Okay,
I just wanted you to have a chance to say, you know what, you got it wrong. Dr. Randolph never had an employment contract, or it's the wrong hospital, or that synopsis is what I'm relying on to be oriented to the allegations that have been brought and the concerns that have been raised. And you're saying that's close enough for government work.
Hang on. On the issue, though, of termination, that's sort of a pivotal issue here. They sent a letter on April the 15th that purported to terminate him. It would be governed by section 2H of his employment contract, which you will need to interpret. And in that letter, on footnote 1 on page 1, they make it clear.
Can you
that-
stop for a moment?
Yes, sir.
Does anyone have that letter that I can, it's not helpful to talk about footnotes in a document that.
Okay, it is exhibit. I can tell you what the exhibit number is.
Great, I've got all that. So you just tell
Exhibit
me
20.
what it
It's
is.
exhibit 20 in the Dr. Randolph's exhibits and in the defendant's.
All right, I've got it.
exhibits. It's
Okay.
exhibit 7 in the defendant's exhibits.
Okay, I'm looking at plaintiff's exhibit 20.
Got it. Okay, it's the same thing, Your Honor, as defendant's exhibit 7. Now, that letter, which purports to terminate him, leaves open the question, which is count 2 of the complaint, which is not what we're here for today,
Right.
on whether it's a cause or not for cause termination. But what's important, Your Honor, is you have to look at section 2H of the employment agreement, which is it is Dr. Randolph's exhibit number 1, and it is defendant's exhibit number 1. It's exhibit 1 for both of us. So if you go to section 2H, 2H says that if physician's employment is terminated for any reason, physician will resign from the professional staff. Physician irrevocably appoints the president of employer, and I assume that would be Jonathan Watkins, or his designee, to submit the resignation if physician fails to do so within 72 hours. All right, according to the affidavit of Jonathan Watkins, the letter was sent, Dr. Randolph never resigned, and they've never tendered his resignation. So I don't know that he is terminated, Your Honor. I think that's an open question right now.
I wouldn't spend a lot of time making that argument, but I hear you.
Well,
I've read the language. I've also now read the letter, which makes pretty clear what the hospital intended to do. Now, they may not have dotted that final I by doing what really Dr. Randolph should have done per 2H, but that's fixable, I would assume, in about 15 minutes by having a letter written on his behalf submitted. But like you pointed out, count 2 is not before us today. It's count 1.
All right, now take that to the next step, Your Honor. If they terminate him, most employment contracts in hospitals say if you terminate someone, they don't have any peer review rights, and then there won't be any peer review hearing. If what they are saying is that we are terminating him and the peer review process is over, which they haven't made clear, I think that's a pivot point right here, Your Honor.
Okay. Now let me ask counsel for the corporate defendants and Mr. Watkins, any amendment you want to make to my summary of sort of what I think got us to this point? Okay. What is the answer to the question that Mr. Cochran just posed? Why go through with a peer review if Dr. Randolph has been terminated?
That is a good question. I was going to actually address that. Excuse me, Judge. Judge, excuse me. I can't hear him.
Okay, so
I cannot either,
Can
Your
he
Honor.
call?
I'll unmute, but if it creates problems for you, let me know.
Okay,
Can you hear me now?
I can hear you now.
Okay, thank you. This is Victor Moldovan speaking.
Okay, thank you.
Okay, you're welcome. Right, so our position is that we were going to allow and wanted to allow Dr. Randolph the process to go through this hearing and make a determination as to whether the original suspension was appropriate or not. Mr. Cochran is correct. We could, but have not yet taken the position as a result of his termination, with or without cause. It doesn't matter. We could take the position that he is now off the staff and doesn't have any rights. We have not yet taken that position to allow this process to continue, to allow him the opportunity to go through the peer review process, make a determination as to whether or not the suspension was correct or not. One of the things that has come up in the context of this is there's a report to a national data bank that was made by the hospital. Depending on the outcome of the peer review process, that could be modified. It could be modified where if he is successful, it would be reported by the hospital that way. If it's not successful, maybe something different. So we wanted to give him the opportunity to go through the process. If they do not want to go through the process, we're happy to go ahead and take that position, but we've not taken that position.
So it was a purposeful decision to not submit the resignation letter on behalf of Dr. Randolph per 2H.
Does at this point is terminate his employment. The termination letter, the resignation letter is on his privileges. So the privileges technically are still out there, subject to this process. So we didn't want to take away that opportunity for him to go through the process, and we're willing to continue on the process. If he does not want to proceed, obviously we're fine with that. We're assuming he does, but we have to get on.
I'm assuming he does too. Let's clear up at the get-go the difference between employment and privileges for me, so that I don't get confused by this.
So he's employed by the PC, which is the CTCA PC entity, as a physician employee. And then as an employee, he has the right to get staff privileges at the hospital, which is a hospital entity, the hospital entity. They're actually two separate things. There's employment and there's hospital privileges. In the CTCA matter, to have privileges at the hospital, you have to be an employed physician, but they're actually two separate things. Once you get employed by CTCA, the PC, you apply for privileges at the hospital. There's an application process that Dr. Randolph went through. They were granted. As a result of that, he has the rights under the bylaws. But upon termination of the employment, which is the termination of employment contract, there is an obligation on his part to resign from the staff at the hospital, because basically it's a closed staff. You have to be employed by CTCA. So those are the two different things. So it's two separate tracks. They interrelate because the contract requires you to resign. But at this point, we've not yet done that.
So I could be employed by CTCA, but without privileges, I wouldn't be of much, as a doctor, I wouldn't be of much value. Correct. Because I wouldn't have the privilege to practice oncology, whatever the field is, at the CTCA hospital.
Yes, correct.
I might still have my privileges after I was terminated, but that's a situation it seems like CTCA would want to clean up real quickly, because it sounds like I could show up at the hospital saying, you have to let me do this procedure on this person because I have privileges to be here, but I don't actually work for you anymore. That's an odd.
So this process here, assuming that Dr. Randolph is successful going through the peer review process, and the determination is made after the various iterations of appeal that in fact the suspension was incorrect, the hospital would then have to basically rescind the suspension or correct the record. But at that point, he would effectively have to resign his privileges. But the reason that's important is because of the data bank reporting issue, is that if he's successful in the suspension determination that it was wrong or should be reversed, the hospital's obligated to go into the data bank and then report that he was successful. And that clarifies for him when he goes out and tries to find another job, that data bank has been, he won the appeal, it was resolved, the hospital lost potentially, So it's important for him, I think, to do that. And we want that opportunity for him to continue.
Because if I'm a future employer of Dr. Randolph, I can look into that database. And if there is an entry that says suspended, lost privileges at CTCA, that's a red flag. If it is cleared up as a result of this litigation in his favor, he may still have to explain why he only lasted for 4 months at CTCA, but there's not in the database something that said peers found or compatriots found that he, these are my words, wasn't fit to practice at this location.
Correct. As a physician and just working, from my experience, working in the field, I think that's important to Dr. Randolph. And we understand that. And so we want to have the process continue He will not come back to work at the hospital. He will not work for CTCA again, as a result of the termination. But we think it's important for him and for the process to continue to allow him that opportunity to address that issue.
Your Honor, may I be heard?
In a minute. Mr. Kruger, anything you want to add? I don't intend to be asking a whole lot of questions of you. I think I may have, I don't know who will be saying it on behalf of Dr. Shakibnia, but I certainly have a question front of mind, this allegation that Dr. Randolph has raised. And I'm not asking you to answer it now. I'm just letting you know that during the course of this afternoon, I'm going to want to have this question addressed, this allegation that Dr. Shakibnia is an economic rival or competitor of Dr. Randolph. And so it's not appropriate for her to serve on the peer review panel. And I've heard the response from Mr. Moldovan and Mr. Schnell. I've read it. I haven't heard it. I've read it. But that may involve some dialogue with Dr. Shakibnia. I'm not sure. I know there's this motion to quash a subpoena that was brought to have Dr. Shakibnia testify. I don't know about what, if it's not beyond, if it's beyond this question of economic rivalry. But I just want to forecast that the only question I might have about any of your three clients is about that allegation that structurally Dr. Randolph and Dr. Shakibnia were, not anymore, but they were economic competitors. With that said, is there anything you want to add about the setting?
No, sir. I think everything you said is right.
Okay, thank you. Mr. Cochran, what did you want to add?
All right. If you would go to exhibit number 2, which are the medical staff bylaws. Now, this goes directly to the point we're discussing about termination and section 2H of the employment contract. I mean, this is a pivotal point, Your Honor. Let me know when you've got the bylaws up. They're exhibit number 2.
I've got them. I'm looking at them.
Okay, go to page 38 to section 9.4.4.
Okay.
All right, so if you look at 9.4.4, this is where there is a direct connection between employment and clinical privileges. Because as you can see, it says that your clinical privilege, it in effect says clinical privileges are driven by that contract and controlled by that contract. So if they have in fact terminated him, then there's not going to be a peer review hearing, and the only issue is the termination with or without cause.
Well, I guess you're confusing me now because, of course, there is a peer review hearing, and I haven't heard that any of your reasons for continuously moving the date for the peer review hearing had anything to do with, well, wait, what about 9.4.4? And we can make this a real short hearing. If Dr. Randolph doesn't want the peer review hearing, we're done. The injunction request is moot because there would be nothing to delay for there to be a new set of peer review members selected or anything like that. So I'm not sure what your point is. I see what 9.4.4 says. And I heard Mr. Moldovan say, we, the hospital, could say, you know what, we're done. You've been terminated, and we'll just have the database say what the database says. But they are electing to afford Dr. Randolph the opportunity of the peer review hearing. If that's not something that Dr. Randolph seeks, then we've taken care of count 1, and we can turn this into a status conference where we just talk about scheduling for the remaining counts.
Here's the point I want to make, Your Honor, is yes, 9.4.4 is out there. The letter that was sent scheduling the hearing for May the 22nd was sent on April the 14th. The letter terminating Dr. Randolph was sent April the 15th, and the hospital has been very coy about this, not responding to any of our communications. So today is very beneficial to address the issue of what is the hospital's position. And I think I've got a chat here. I think Jim Blitch wants to say something.
Judge, I could just briefly say, I think the confusion going into this hearing today lies in, first of all, the examination of 2H as we're doing, but also in the brief that the hospital has filed, and they make the point that because of they're referencing 2H in the employment agreement, and they make the point, which they're now disagreeing with, but their point in their papers quoting, at this point, Dr. Randolph privileges are terminated. The way the contract reads and the fact that there hasn't been a resignation, and most importantly, Mr. Moldovan's point that they are acknowledging his privileges and they are willing to hold a hearing, that clears it all up in my mind, because yes, Dr. Randolph does want a peer review hearing in accordance with the bylaws. So thankfully, you've put your analysis to it and gotten us right to the point. And I believe that in the comments and the notes I took from counsel for the hospital, they acknowledge that his privileges are still there and that he is entitled to that hearing. And they have even admitted that it's very, very important to him because of this report out there to the National Practitioners Databank.
Okay, well then it sounds like we agree. Let me ask a question before we get to the injunction analysis. Is there any opposition from Dr. Randolph's legal team to having the unredacted version of the, I'm going to call it hospital for short, the hospital's response to the motion for the interlocutory injunction filed under seal?
No objection, Your Honor.
Okay. I will sign an order to that effect, and I saw there was a proposed one, so we'll work through that. Do we need to address the disagreement over the subpoena to Dr. Shakibnia? What role did you envision the doctor playing in today's proceedings, Mr. Cochran or Mr. Blitch?
Okay, I'm not muted. We anticipated calling her on cross-examination. Now, I have filed a response to their motion to quash, and it seems to me, Your Honor, that this is sort of a pivotal issue here at the outset that we need to address. So with that, Your Honor, I'm going to sort of turn it back to you. How do you want to handle the motion to quash the subpoena to Dr. Shakibnia?
Well, I'd like to start by you letting me know what you were going to ask her about.
Okay. Number one, get into the facts and circumstances about whether or not she is a direct competitor of Dr. Randolph's. That is, who does she treat? Who does he treat? What is her specialty? What is his specialty? Those kinds of things, number one. Number two, who's really been pulling the strings behind the scenes here in terms of controlling, A, the decisions about these postponements, B, who's made decisions about procedure? For example, it's the hearing officer who's supposed to decide all procedure here under the bylaws. Not Mr. Watkins, not Mr. Moldovan, not anybody else, only Dr. Shakibnia. And while we have made it known several times, for example, that given my age and the fact that my wife is recovering from chemotherapy and is immune compromised, I cannot attend an in-person hearing. And yet they've announced that the hearing is going to be in the conference room at the hospital. And then it says, if we need an audio or video conference, we'll make the arrangements, but no arrangements.
We are not going to spend the limited time we have today working through the logistics of the hearing. I was
I
able to
understand.
connect all of you in this way. I'm confident that a sophisticated organization like the hospital could connect people in this format as well. Happens all the time these days. And I wouldn't be issuing an order that says the hearing is postponed until everyone gives the all clear on every front with COVID-19. So that's not going to be the outcome today, regardless. I don't want us to get that granular, but I do now have a question for Mr. Moldovan, or it could be Mr. Kruger, about Dr. Shakibnia being asked questions about the degree to which her practice competed economically with Dr. Randolph's. That doesn't seem to be covered by the absolute immunity / privilege that was cited in the motion to quash. I read that to be Dr. Shakibnia cannot be asked anything at any point, at any time, in the same way that Dr. Hansra could not either, about what happened in the peer review and why did you decide this and what was the testimony. In the same way you don't get to interview jurors. That was my understanding, limited understanding, of the type of protection Dr. Shakibnia enjoyed as not just a member of the peer review group, but as the chairwoman of it. That doesn't seem to be coverage that would extend to a line of questions that come up before the hearing has ever happened about whether there would be a basis for Dr. Shakibnia to step back from the peer review panel along the lines of the doctor who had treated the same patient that Dr. Randolph did, not because they were competitors, but there would have been reasons why one might be concerned that that doctor was bringing into the hearing outside information that a neutral decision maker ought not to have because he had dealt with the same patient Dr. Randolph did. So I wasn't overwhelmed by the motion to quash only because I had predicted that Mr. Cochran wanted to talk to Dr. Shakibnia, not about how she intends to run the hearing, because that's not something he can ask her about in this setting, but much more so on the propriety of having an economic competitor serve as, well, that's not even it, is are you an economic competitor? I didn't see that as being covered by the motion. So I don't know if that's going to be Mr. Kruger as counsel for Dr. Shakibnia, or if that's Mr. Schnell or Mr. Moldovan. I thought the motion came from you all.
This is Victor Moldovan speaking again. This is Victor Moldovan speaking. I'll go first, and Walter, obviously free to chime in. So the cases we cite in the motion or Georgia cases are very broad. Basically what they say, there's no bylaw exception to the privilege. And that's the quote that we have in the motion, Judge, which I know you've read. And so it's pretty clear that there's no bylaw exception, which means the argument they're making here is that under the bylaws that we're dealing with, that it says in our own bylaws that there's not supposed to be a direct competitor on the hearing. But if you look at section, and the reason that this is important, if you look at section 10.33, which is no practitioner, this is on page 42 of the bylaws, no practitioner in direct competition with the practitioner may serve. Okay. And it does say that. But then it also says, and the reason why this is important is under 10.3.4 is to avoid this sort of scenario we have now running to court to have this argument about this, is that the decision is in the sole discretion of the chief of staff. They have the right to raise the objection, and they raised two objections. One to the first doctor that you referenced in your summary about there's a patient that they shared, the chief of staff said, fine, we'll take him off, we don't want, that's potentially, but he had this objection in front of him and clearly rejected that objection, and it's in his sole discretion. What they're asking you to do, court, at the court, is to come in and say, I'm going to overrule his discretion. It's not just discretion, it's his sole discretion. His determination is that that was not a legitimate objection to remove her. The court, again, with all due respect, should not be stepping into the bylaws of the process. It's set forth in the bylaws. They're arguing that we have to follow our bylaws. Bylaws are followed. And that's our position is there's no need to even talk about the issue. But the idea that you would then say, well, yes, it's in his total discretion, but we're still going to let them present evidence about it anyway. If they really think there's economic competition, Dr. Randolph can testify to it if they really want to use somebody. you don't have to even get to Dr. Shakibnia. And so our position is that no, it's covered by the privilege. There is no bylaw exception in the privilege. The idea is, again, that we don't have the opportunity and reward is to run to court to try to disrupt the process, which is why it says sole discretion, to avoid this exact argument.
Mr. Kruger.
Mr. Kruger, did you want to add anything to that?
Just a couple of sentences. One is the fact that when Dr. Randolph was employed, he worked for the same group that Dr. Shakibnia works for. So this is not like, it's an independent hospital where you had two practices that were private and they're both delivering babies, and you wouldn't want one practice to try to get the other one disqualified. This is not like that. So it really doesn't apply because of that. The second point is that given the situation now, which is that Dr. Randolph is not employed and is not going to be employed at the hospital, it's moot. There's no way there can be any. I don't think there were competitors economically, really, because they both had a contract and both had salaries. But now there's no way they can be competitors because they won't both be employed or at the hospital. That's all I was going to say.
Mr. Moldovan, who is the chief of staff?
Dr. Yohana. And if you look at some of the letters, Dr. Yohana is chief of staff, and he's the one who appointed the committee, the hearing committee.
And he's the doctor who initially suspended Dr. Randolph, that then went to the investigative panel, and now we're here. Okay, so Dr. Yohanda is the chief of staff. Mr. Cochran, has your legal team, or did Dr. Randolph directly, consistent with 10.3.4, submit a written objection to Dr. Shakibnia's participation in the peer review panel?
Yes, we did. It's in writing and it's one of our exhibits.
And Dr. Yohanda, I guess, overruled that objection.
We don't know. They don't tell us who made any decisions. We have no idea if Dr. Yohanda had any involvement in that, or whether it was Mr. Moldovan or whether it was Mr. Watkins. We don't know.
Well, the fact that Dr. Shakibnia was not removed, is that not pretty good circumstantial evidence that the objection was denied?
Oh, absolutely. We just don't know who did it.
So you very much want the hospital to comply to the letter of the bylaws. Why should we not comply with 10.3.4 and allow a judge to butt in and second guess a decision that was made pursuant to 10.3.4?
Because first of all, the first decision is who made the decision not to disqualify Dr. Shakibnia. Was it the chief of staff or was it somebody else?
So why don't we have Dr. Yohanda here? When you are ready to ask him some questions, then we might get to Dr. Shakibnia. But for now, I don't feel that it's appropriate for Dr. Shakibnia to be subject to the type of examination, meaning the nature, the types of questions you were going to ask. You may get there, but it doesn't sound like that's going to be today because I don't see Dr. Yohanda on this call. Let's turn to the
Judge
injunction because we do not have all afternoon, and I would like to hear from plaintiff why it is that he thinks he satisfies the requirements of an interlocutory injunction. I guess what I'd like to start with is the obvious one, which is the irreparable injury or the harm. Given that Dr. Randolph has been terminated and the hospital has made it clear that, Mr. Kruger, you're on mute.
Thank you. I wondered, is it okay if Dr. Shakibnia is excused and she can go be a doctor?
I don't have an issue with that. Anyone else need her to stick around? Okay.
Your Honor, you're not going to allow examination of Dr. Shakibnia?
Not until you ask Dr. Yohanda some questions that make it clear to me that you ought to be asking. You speculate, and your speculation is not going to get you to Dr. Shakibnia. If you can establish something beyond conjecture or a conspiracy theory, then it may become appropriate to ask Dr. Shakibnia some of the questions you want to ask. And I'll hear from you in a minute, Mr. Blitch. But you have to overcome the mootness point that Mr. Kruger made, and you have to overcome the absence of evidence that there is this cabal going on led by either the CEO of the hospital. You haven't alleged that Dr. Yohanda is up to no good yet, but there's a lot of claiming that other people are making decisions with no evidence of it. So that would need to come from someone other than Dr. Shakibnia. You get me that, then you may have cleared the gate you need to clear to get to Dr. Shakibnia. Mr. Blitch.
Thank you, Judge. I just wanted to back up for one moment on the direct economic competitor question that the court's put its finger on. And I understand Mr. Moldovan's point about 10.3.4 and discretion given to the chief of staff if an objection is raised. However, in their own contract, if you go to 10.3.3, and they drafted this, of course, not a radiation oncologist. It is very blunt, very specific. It says no practitioner in direct economic competition with the petitioner may serve as a hearing committee member. So you have really a classic question for the court to consider about interpreting a contract, and it has to be construed against the drafter. Hornbook laws, the judge, Your Honor, knows better than me, but they have created this problem because they've said, and it makes total sense if you talk about fairness, Dr. Shibnia is a radiation oncologist. The other two on the committee, we'll get to the testimony of this if the court needs it, but one's a medical oncologist and the other is a urological oncologist who do not compete with Dr. Randolph. So their contract puts it out there that a direct competitor cannot, it doesn't say, see, you know, we'll also decide if you, so it's frankly in conflict. In my view of Georgia contract law, and this is the last thing I'll say and I'll shut up, is that the more specific, if you will, provision in a situation like this controls. And they've made an absolute statement that doesn't give discretion on an economic competitor. Other composition, I agree that, other competition, I agree. Other types of doctors, excuse me, they can exercise discretion. Sorry.
Okay, I hear you on that. And presumably those points were made to Dr. Yohanda in the written objection that was made to Dr. Shakibnia's participation in the peer review panel. And that objection was deemed to be something that ought to be denied. And Dr. Yohanda is the best person to talk about that, not Dr. Shakibnia. I'm confident that the basis for the objection was made, not simply we object to Dr. Shakibnia. And that's who I'd need to hear from before we talk to Dr. Shakibnia about it. So when you're ready to do that, we can do that, but it doesn't seem like that's going to be today. So I'm going to let Dr. Shakibnia go back to being a doctor. And let's turn to the question I had posed, which is, please help me understand what the irreparable injury is that confronts Dr. Randolph such that we ought to delay yet again the peer review panel in light of the fact that he's been terminated, and we have heard in no uncertain terms that regardless of the outcome of the peer review panel, Dr. Randolph is not working at CTCA again.
The irreparable harm goes to the underpinnings of the Robles case and the St. Mary's case and the Madonna case, which is the obligation to follow the medical staff bylaws. And under the circumstances here, Dr. Randolph is not being afforded a fair hearing. If he's not afforded a fair hearing and he loses his livelihood, loses his profession, ends up with the National Practitioners Data Bank report, ends up with a report to the medical board, and loses his career, then his remedy is to try to put the genie back in the bottle after the fact. And that's a very tall order. So That is the irreparable harm. And under Georgia law, particularly the Grossi Consulting versus Sterling Currency at 290, that's 290 Georgia 386, and Cotton States Mutual Insurance Company at 290 Georgia Appellate 660, Cotton States versus Stephen Brown Insurance Agency at 290 Georgia Appellate 660. The question here is there a balancing of the inconveniences? Who is going to be harmed by a continuance, or in this case, by a postponement of the hearing, which is what we're requesting so that they comply with their bylaws?
So I hear you. What is it that you would try to have happen between now and hearing date number 6 or whatever we'd be on if this one got continued as well? You'd want Dr. Shakibnia off the panel. There's this conspiracy theory about, I have yet to see any evidence for it, but today's your day, that Mr. Watkins is the string puller and the puppet master, and I don't know why he's got it out for Dr. Randolph, but that's the theory of your case. What is it that would change apart from, and I don't ever mean to minimize this, the legitimate concern about health and well-being? Ideally, it would be a peer review event where everyone is in the same room. That's complicated. That's not the basis of your motion. And more, that's not a basis for delaying things throughout Georgia or around as we try to move forward. So setting aside the COVID-19 concern, what is it that you think would be different if we bumped this to June, to July?
All right, if you look at our complaint, let me back up, because this goes really to a fundamental concept of administrative law, Judge McBurney. The prosecutor here, if you make an analogy to a criminal case, the prosecutor here is the medical executive committee. All right, and the medical executive committee, if you look at their bylaws, in section 16.2 on page 57 of the bylaws, Mr. Watkins is a member of the medical executive committee. He is an ex officio member of the prosecutor. Now, all of the communications so far that we have received in this case have come from Mr. Watkins. He has communicated on behalf of the MEC. He has communicated on behalf of Dr. Shakibnia, who is the chair, and who, going back to my analogy, Dr. Shakibnia would be the judge like you are. She's the person who's supposed to decide what the procedures will be, what is relevant, what's admissible, who gets to testify. She would be doing exactly what you're doing. But all the communications that should have been coming from Dr. Shakibnia have come from Mr. Watkins. And Dr. Randolph wrote a number of letters directly to the hearing committee to find out, what are you deciding? What is your role? So you have the prosecutor, who is the MEC, and that's Mr. Watkins, who's part of that. You have the judge, who's Dr. Shakibnia, and then you have the hearing committee, which is supposed to be the jury in the analogy, and all of their communications are coming from Mr. Watkins. I mean, we allege this in our complaint. We made it clear that all of the communications that we have received have been orchestrated by Mr. Watkins.
Now you say orchestrated. I'm going to stop you because you use these verbs that you then don't back up with evidence. The fact that a hospital administrator is the primary communicator of administrative details while these doctors are taking care of patients, to me seems unremarkable, not nefarious, and not the basis to conclude that there has been procedural unfairness. I don't mean to acknowledge that there are due process rights that your client enjoys in this private matter, because I don't think they exist. This is not a state actor, but I'm all for fairness. But it seems unremarkable that the job of communicating is delegated to an administrative individual while the doctors do their business until it's time for the hearing. And then they come in and they consider the evidence for or against whatever is being advocated. So what am I missing in being underwhelmed by the fact that they delegate to an administrator the role of communicator?
Well, perhaps it's my experience. I have been involved in dozens of these proceedings in the past. And in every other situation in which I have ever been involved, the hearing committee had their own independent counsel, and they were not having all of their decisions made or communications made by the administration of the hospital. They had and under these bylaws, they can have their own independent counsel. And
they
we
can
have asked,
have. And when you say decisions made, of course, you are not talking about the single important decision, which is the result of the peer review process.
Correct.
I'm hearing you talk about procedural decisions like, are we going to reschedule, and announcements like that. What more substantive decisions do you perceive are being made not by the peer review panel, or you call her the judge? It's the hearing officer. She's not the judge. She would be one of 3 votes that would decide Dr. Randolph's fate in terms of his privileges. But tell me what substantive decisions you can demonstrate have been made incorrectly, improperly by someone other than the hearing panel that hasn't even convened yet.
I think Mr. Blitch may have something. Jim?
Judge McBurney, to your question, I think, and you said this is your time to put forward some evidence, and we can do that if need be, but I can certainly summarize as an officer of the court. And it is really the key question. What is the origin of Dr. Randolph's concerns? And I think first of all, you've already looked at his contract, and I think I ought to just step back in one moment, tell you, he is a graduate of, I hope you won't hold this against him, but Yale University. He went to Mount Sinai Medical School in New York City. He did his residency at Emory University, has been in Atlanta basically ever since, with the exception of a 3-year fellowship in oncology at MD Anderson. He was offered and accepted a contract with CTCA. He has never worked before in Noonan, Georgia, but he signed on to work at this hospital. He was given $455,000 annual salary, as you said, a very nice signing bonus, opportunity for revenue enhancements based on productivity. And 4 weeks later, 4 months, excuse me, I apologize. 4 months later, which is a small amount of time in the life of a person this accomplished who's been doing this for 30 years, you have this slate of 8 problems with patients and sort of these wild accusations that he doesn't know how to administer radiation to breast care patients. Or
stop for 1 second. So Mr. Moldovan's objecting. I'll let him state his objection. It may have been on mute, but in general, if the lawyers are talking, you don't need to object. You'll get a chance to speak your piece afterwards. If there is a witness testifying and you want to object because the question may elicit something that's not admissible, let's do that. But save I'm going to hear you out in just a minute, Mr. Moldovan, but save your disagreement to when I say, all right, we just heard from Mr. Blitch. What does the hospital's lawyer have to say? Do you want to save it?
I was just going to point out that because he's referencing the actual substance of the merits of the issue, he just talked about 8 cases. We scrupulously did not. That's under seal. So I don't know if he realizes. I mean, if he wants to put it out there.
No, I do, Judge. That's very important, and I appreciate Mr. Moldovan. I understand that's not what we're here for, and we're not talking about those. I'm just giving you the basis, and that's now been filed under seal. So we're not talking about the merits of the peer review findings, but 4 months into this contract, here comes this. Then they say you should do, we've already talked about this, all of the testing that MEC required. And then there's a statement by the hospital president and CEO that he did not do it. And so we were prepared, sounds like we've moved on from that, to show that he did in fact do the testing required of him. The hospital in fact paid for it. I don't know if the right hand doesn't know what the left hand is doing, but he did it. And then the final point I think I would add is that we've already touched on this, but it's a legitimate reading of the contract. There's an economic competitor, another radiation oncologist who's chairing this hearing committee. So add up that evidence, and those are the concerns that Dr. Randolph believes are at the heart of why something is happening here to railroad him out of here, or something is going on. And so, yes, he wants a fair hearing, because the most detrimental thing that has happened here for a man, a very, very accomplished doctor who's been doing this for 30 something years, is he's never ever, and he can testify to this, he's never ever had a report to the National Practitioner Data Bank. That's kind of a nuclear option button. And it's his livelihood. And so he wants a hearing. And until today, until I heard from Mr. Moldovan, their papers say he doesn't have any more privileges. Now they're saying differently, and they're allowing the hearing. But all of that evidence that I put my finger on or tried to summarize for the court points to our concerns that this is not fair, and something is going on here that really truly affects a very accomplished person's livelihood.
Your Honor, this is Mr. Cochran. Let me add one thing here. The hospital submitted the affidavit of Jonathan Watkins. And in that, and if you look at it, particularly on page 5, in paragraphs 15 and 16, he specifically gets into the very areas that we want to inquire about. That is the procedures, not the underlying medical issues, but the procedures. And if you look at his affidavit, Mr. Watkins says that he is very knowledgeable. He's the CEO. He's well aware of everything that's going on in the hospital. And the only thing that he says about the process is that Dr. Yohanda appointed the following individuals. He doesn't say who selected them. He says that Dr. Yohanda appointed them. And then he says that he, Mr. Watkins, had no role in and did not appoint any hearing committee members. Well, I would suggest, Your Honor, that under OCGA 24-14-22, they've just raised a presumption, because if a party has evidence in their power and within their reach that they can repel a claim or charge against them, but omits to produce it, that raises an inference. I think you can draw an inference from what they didn't say in Mr. Watkins's.
Mr. Cochran, I am sorry, I got to stop you. Tell me, what about paragraph 16 would lead you to argue what you're arguing right now?
That's all they're saying. They've got information. If we have challenged the selection of the committee, the economic competitor,
but you're tripping over a verb.
Forget about the distinction between appointed and selected, although that's very clever of them. The point is, if he can talk about how the hearing committee was selected and his involvement in that process, why can't he talk about whether Dr. Shakibnia is a direct economic competitor? Why can't he talk about all these other procedural issues that we've raised?
I don't know. Why are you asking me? Why aren't you asking him? Why didn't you subpoena him or Dr. Yohanda? You had Dr. Shakibnia show up.
Because she can testify to whether or not she treats the same pool of patients as Dr. Randolph. And as Jim Blitch pointed out, that's an absolute prohibition. It's both in the bylaws and in the Healthcare Quality Improvement Act, 42 USC 11,112. You cannot have a direct economic competitor. That's just a flat prohibition. And we don't need Dr. Yohanda to prove that. Frankly, Dr. Randolph can testify to the facts that we need to prove that she's a direct economic competitor.
Well, and why did we drag Dr. Shakibnia in here?
Beg your pardon?
Then why did you drag Dr. Shakibnia in here? If your own
Because
client can do it?
She can testify to a lot of other things too, Your Honor,
Okay.
about the process, about the decisions, whether things are being dictated behind the scenes by the hospital, and she's not been involved as she's supposed to be as the hearing officer, the judge. And the one other thing I would add, Your Honor, they've invoked the peer review privilege. And under Ostroff versus Coiner, it's OSTROFF versus Coiner, COYNER, at 187 Georgia Appellate 109, their invocation of the peer review privilege can raise an inference because they're trying to prevent us from getting information that would support our claim. And yet they submit an affidavit, they submit a partial affidavit that covers one tiny part of this process, but they omit to say anything else.
Anything more you want to tell me about the irreparable injury that your client would suffer if the hearing went forward as scheduled?
Hang on, just let me look at my notes, Your Honor. Jim, take a look at your notes as well.
I just want to say at this juncture, Judge McBurney, in light of the papers, in light of our reading, which is a very fair reading of their termination letter and that footnote, I think there was a lot of, Mr. Moldovan cleared it up, but there was a lot of legitimate confusion about whether he had his privileges and was entitled to a hearing or not. And as I said a moment ago, their papers even say he does not have privileges. Now
Right.
he does. So I guess what I would just simply say about the hearing and when it happens, I hope the court is thinking that we just now at this juncture need more time because it's not fair to try and do it on May 22nd. And
Because
well, it's just a couple of days away. And I think, you know, we were coming in here thinking that they weren't going to give him a hearing at all. And so.
But why, I guess this is a new argument. I want to give it full play. But it would seem like Dr. Randolph ought to be extra super duper ready because we've had 4 continuances already. And if really the concern was he wasn't going to get a hearing at all, it would seem like the motion wouldn't have been stop the hearing from happening. It would be make sure the hearing happens. But there is no language in any pleading I've read from plaintiff that says make the hearing happen. It is stop it, get Watkins out of the way, get Shakibnia out of the way, this conspiracy theory, and we want a sort of a redo on the composition of the hearing panel, but we're not ready. We just don't think that what we're ready to present would be presented to a fair and impartial committee for the reasons that you all have articulated.
Well, last thing for me on this, I don't want to really speak to that part because that's really Mr. Cochran. I do respectfully understand. I mean, we've all been going through some pretty extraordinary times. I am terribly appreciative of the court and the way you have held this on. I had a hearing the other week in the Court of Appeals on Zoom, but it's only the second time in 25 years I've done this. So it's sort of like, and I know Mr. Cochran has a situation with his wife that causes some concern. So I think It's a brave new world about how to do it in a COVID world. And that's my only concern about May 22nd. I'm sort of an outsider on that part, but I wanted to say that in light of the legal issues that were sort of in front of us, it wasn't clear what we were really doing. I think this hearing has clarified that.
Okay.
And Your Honor, this is Mr. Cochran. Let me say this. I have been alerting the hospital and their lawyers for months about my personal situation. We have reached out to the hearing panel directly. Dr. Randolph did it himself in 4 communications, simply asking who represents the hearing committee. Is it an independent person? With the thought being, once we got an independent person, we could get a rational decision and an explanation, none of which we've gotten. All right, there's a lot of frustration here, Your Honor. And we were told in the last notice, well, we're going to have the hearing in the hearing room at the hospital, which is obviously face-to-face, and yet they have known.
I got that.
Okay.
I understand. And I appreciate Mr. Blitch's final point. And that's one that I'm going to need to weave into however we work through this, that there may be reasons that have nothing to do with the Watkins conspiracy to say, well, maybe we need to wait a couple weeks so that people can get clear answers as to what I'll call the protocols of the hearing. Who will be where, how will people communicate, et cetera. Of course, I'm going to give Mr. Moldovan an opportunity to say, wait, we've shared that with Dr. Randolph's team 4 different times, because it sounds like messages cross and don't necessarily connect. But that's a separate issue that I think goes, again, more towards procedure and public health, and not undoing the work that Dr. Yohanda has already done. Let me hear from Mr. Moldovan or Mr. Schnell about irreparable injury. If there's something you want to add beyond your response, I've read that, but you've now heard the other side speak for a while. So if there's something you want to add, let me know.
Just briefly, we too are appreciative of Dr. Randolph's history, which is why, frankly, we're so confused about the turn of events. Certainly, he was hired with full expectations. He was paid a large cash bonus, a large salary. The idea that there's this conspiracy somehow to hurt Dr. Randolph is obviously we totally disagree with the evidence of, and the underlying facts would belie that. We've never said that Dr. Randolph would not be entitled to a hearing. We've been asking to have a hearing repeatedly. I recognize the health concerns.
The court reporter's waving her hand.
Been in the conference room.
I'm not getting it. I'm not getting everything that he's saying. I can't hear him.
Apparently, the court reporter can't hear.
We can do social distancing. If Mr. Cochran wants to do by video, that's fine. If he wants to have his witness by video, that's fine. We're willing to accommodate anyone's comfort level to make sure that they're comfortable with doing this, but we have to get it done. If he doesn't want to do the hearing, obviously that's fine, but I would think he does. We want him to have it, and we'd like to proceed and get it done with.
Okay. Mr. Cochran or Mr. Blitch, tell me why you feel there is not an adequate remedy at law for your client, Dr. Randolph, if the hearing goes forward, maybe not on Friday, but maybe in a few weeks, so that there can be a few exchanges of logistical information about how the proceeding will occur in terms of who patches in remotely, who is there face-to-face, how exhibits would be exchanged, things like that. Things that we were able to do in just a few days, mostly thanks to Ms. Niles, but the lawyers did a great job of getting exhibits to her. And all you have to do is say, look at bylaws, page 57, and lo and behold, I've got bylaws 57 right in front of me. So it's doable. But setting that aside, tell me why you contend, because you mentioned this genie in a bottle, but I don't think that's the standard. It's no remedy at law, not it would be difficult, but there is a remedy at law. If in the end, your contention would be the hearing was unfair for the reasons you've articulated, but then the hearing occurred, there are unfavorable results for Dr. Randolph, and he believes he has a cause of action as a result of the due process, I have to put that in quotation marks, no state actors here, the due process violations that you've alleged. Why is that not something you could sue about, thus taking away from me the power of equity?
Well, certainly we could sue, but Your Honor, the difference, the irreparable harm is that between the day of the hearing or whenever the hearing took place, be it this Friday or in a couple of weeks, if he doesn't get a fair hearing and his reputation and livelihood get destroyed in the meantime, you can't give that back to a man or a woman.
So, you say reputation destroyed. Is there not already an entry in the database that says, there was an issue with Dr. Randolph, or did I misunderstand how that works?
Yeah, but it's not that. Certainly there has been, and it's not a good thing.
So if I'm a hospital in Macon and I'm looking for a radiation oncologist, Dr. Randolph is looking for a new job. He's not in Noonan anymore with CTCA. and I'm the hospital administrator or the hiring officer, and Dr. Randolph sends some papers, I look in that database right now. I mean, isn't that irreparable harm already done? I'm not saying it's irreparable, but isn't the harm already done? Because what I understood the case to be, and you need to correct me if I'm mistaken about this, because it's, to use your word, pivotal. If a negative outcome for Dr. Randolph with the peer review is that there is no change to the database, and a favorable outcome would be that there is a change, then the harm is already out there, and it was occasioned by his termination, which is subject to this lawsuit. So there is a remedy at law. But the hearing panel at best could fix it, at worst wouldn't change anything. What am I missing in what I just described?
Because what is on the data bank is only an interim notice. It's not a final notice, and he can explain that.
So that's what I would see as the hospital hiring agent in Macon, considering Dr. Randolph's application, and I would be knowledgeable in these things. If I looked in the database, there'd be that red flag, but it would say interim, and that would be cause for me to engage Dr. Randolph on, well, what happened? Oh, it's not final. Okay, maybe we'll hire you in a probationary capacity, and let's figure out, we'll let that investigation work its course. But if the hearing panel that you're challenging concluded that the suspension was justified, that's the right term, what is currently labeled as interim in the database would become final.
And that's why we have to have a fair hearing, Your Honor, because that's what's at stake. You just hit the nail right on the head.
Okay. You may, Mr. Moldovan.
Again, I haven't heard anything about what would be unfair at this point. We're happy to do it in person. We're all going to be there in person. If we're trying to accommodate his concerns, nothing will change about COVID in the next 6 weeks or 2 weeks, nothing. We have to get this done. I would think Dr. Randolph would want to get it done, frankly. So we need to move forward. And if there's some way that it's fair, I mean, in terms of video, we're open to all that, but honestly, we need to move forward. They're just asking for a delay. It sounds like for delay's sake.
Well, I don't want us, we would be rehashing if Mr. Blitch or Mr. Cochran responded, because I think they have clearly articulated their fairness concerns. And I think there are the substantive concerns of how was this panel selected, who's on the panel, et cetera. And I've heard them out, and I will address that when I issue an order. But there's this new layer that Mr. Blitch helped put a finer point on, which is something that wasn't articulated in the papers, which is how can we make sure that if the hearing is going forward with this panel, how can we ensure that folks are prepared for the exchange of arguments and documents, et cetera. And that is very doable. I'm not worried about that. And to your point, it would need to be sooner rather than later, because there are some folks, and Mr. Cochran may regrettably fall into that category, where for many months he's going to need to be real thoughtful about where he goes outside the room with that red clock in it. So that's just sort of where we are. But that doesn't mean that Dr. Randolph's fate is put on hold, in the same way that it doesn't mean a guy stuck in jail facing armed robbery charges has to stay there forever because there's a lawyer representing him or her for whom it would be complicated to come into court. We will develop workarounds and have developed workarounds. So we don't need to engage on that part. Was there anything you wanted to add on behalf of the hospital about remedy at law? That was the question.
Yes, sir. Just the complaint clearly they have filed a lawsuit for damages that is out there. We expect to deal with that pretty soon. Obviously, we'll deny that they have a claim, but they have a claim in the complaint. So to the extent that they're claiming damages, they do have a remedy in law. We disagree with it. So obviously, if they think they have one, they can pursue that.
Mr. Cochran, if in the end the hearing goes forward and there's an adverse outcome for Dr. Randolph, what would prevent you from articulating as additional damages the loss to Dr. Randolph because a procedure that you would have to convince a fact finder was unfair and violated some right or contractual right that Dr. Randolph had to a different hearing with different participants. That seems quantifiable to me. There would be the loss in income and prestige, et cetera, and good plaintiffs' lawyers argue for those kinds of things all the time. How is this different? I follow you that it is a larger quantum of damages. I'm not disagreeing with you on that. I'm just struggling a little bit on how there isn't a remedy for Dr. Randolph if the way events play out is that there is a peer review hearing that doesn't meet with his requests, Dr. Randolph's requests. There's a bad outcome for Dr. Randolph, but ultimately it's presented to a fact finder that there were meaningful missteps, errors, violations in the way the panel was comprised and the way in which the hearing was conducted. Then there's harm to Dr. Randolph because it's now a final adjudication in that database. And a good plaintiff's lawyer has a field day with that, articulating what Mr. Blitz started. The very impressive credentials of Dr. Randolph, a spotless history, and now he can't get a job. And that's a math problem, as opposed to the courthouse doors are barred to that kind of claim. That's how I see it, but you've done many of these. I've done 0 of these. So I want to hear you out on that, but I'm just not getting the sense that there aren't remedies for Dr. Randolph if in the end mistakes were made.
Here's the irreparable harm to Dr. Randolph. The gentleman is in his 60s. He's only got a limited number of years left to practice medicine. He loves to practice medicine. If this goes forward without a fair hearing and the worst occurs, whether or not he could recover money damages umpteen years from now after an extended judicial process will not give him back these years when he could otherwise practice medicine. Because as you've pointed out, you've got the National Practitioners Data Bank report out there, and that's going to make it, if he doesn't get a fair hearing and he gets a bad outcome, he can't practice medicine. Now, maybe you can give him some money later, but you're not going to let him treat patients. You're not going to let him do what he's done for the last 35 years.
I appreciate that, but how is that different from the person who is harmed and loses his livelihood because he loses his leg in an accident that's the fault of someone else, and it was the place kicker for the Atlanta Falcons? He's not able to kick another field goal again, and there's a remedy for that. There's not only the loss of wages, but anything else that can be quantified because those experiences were denied that person. And I'm not trying to trivialize the life-saving work that Dr. Randolph has done as an oncologist by comparing it to a field goal kicker. But these instances come up all the time where the harm that is caused deprives the victim of not just money, but experiences, loss of consortium, things like that. Is that not recoverable?
Well, but I don't think that's the standard for this relief we seek. Under the Cotton States case and the Grossi case, the trial court must balance the conveniences of the parties pending the final adjudication with consideration being given to whether greater harm might come from granting the injunction or denying it. The greater harm here is clearly, the greater harm is clearly going to fall on Dr. Randolph. They've made it clear. He's not going back in their hospital. They don't have any harm here, okay? There is no harm to them. All we are asking is for them to do what they've already obligated themselves to do under the bylaws. And I want to add one more thing. Victor suggested that they have been trying to offer procedures over time and work with us. Your Honor, that's just not accurate. I would ask that you look at Exhibit 16A that we submitted, which was Dr. Randolph's letter to the hearing committee on March the 31st, 2020, and just read it. I'm not going to argue about it. We got no response to that letter. just read, I implore your honor, read Exhibit 16A. And
Okay.
that's the way we've been treated through this whole process.
So let me ask Mr. Moldovan a couple questions based on some of the things you just said, Mr. Cochran. One I had come up with all by myself, it's on my pad, but the other one I wasn't aware of. I had not seen 16A yet. But Mr. Moldovan, there are a bunch of factors I need to weigh, and no one needs to bat 1,000 on this, but I think Mr. Cochran makes a good point that if I'm balancing the harms, while the hospital is no doubt and reasonably so anxious to get closure on the Dr. Randolph matter, it seems like it is more of an administrative inconvenience to say, we're going to move the hearing down the road a little bit, as opposed to what's at stake for Dr. Randolph. Would you agree with that, that factor at least weighs pretty heavily in favor of Dr. Randolph?
I guess I would not. Again, if we were talking, this is the first hearing date, I would understand that. This is the 5th hearing date. And it's not easy to get 3 cancer doctors in the same room for hearing date. Dr. Randolph's counsel has identified 2 expert witnesses already. He's provided names to us. Both of them are practicing in Atlanta or Friday. So the idea that we would simply say, oh, look, we can just move it, it's not easy to move. This is a very hard, actually very difficult situation for us to do, which is why we're saying, let's do it. Let's get it done. Again, this is the 5th time we've done it. What will change 2 weeks from now? Nothing's going to change. In fact, I think it will be more difficult now to get everyone rescheduled to have this hearing. And I do want to point out that Dr. Randolph could win this hearing. He could come with his experts and say, and they may find that the suspension was wrong. Let's get this done and move forward, because nothing will change. And again, I haven't heard anything about what the delays will change. I can expect that if we get a delay, they'll come running in here saying, well, now we have to depose this person. We have to do. That's what effectively is trying to do here, Judge. So we need to go ahead and bring this closely.
So in that vein, what is your response to Mr. Cochran's observation that Dr. Randolph has on a number of occasions sought clarification of what's going on, what the procedures will be, or who's in charge, who represents the hearing panel? Questions that deserved an answer. They may not have changed anything. As I understand it, the hearing panel can have representation. It's not required to. So one answer could be, we don't have any. What's next? Or we've asked Mr. Watkins to serve as our point of contact. It might have dispelled a lot of the conspiracy theories. But Mr. Cochran says there were several communications that went unresponded to. That does not seem to have instilled confidence on Dr. Randolph's part that they were taking his situation seriously. You're speaking for the hospital. What happened there? Is there a missing piece, wrong address? What happened?
So I'm happy. I had a conversation or two with Mr. Cochran at the beginning of the process. As those conversations progressed, the conspiracy theory argument kicked in. And if you look at the barrage of emails that I got from Mr. Cochran, there seems to be this underlying conspiracy argument that somehow we were out to get Dr. Randolph, which is actually not true. At some point, I decided that it would be more productive for me simply to stick with the bylaws, stick with the process, and try to talk to Mr. Cochran and make sense. Because every rabbit trail went down to another rabbit trail, and then another rabbit trail. And today, another rabbit trail about the idea that we were really not going to give a hearing, even though we were insisting on giving the hearing. That's a new one, Judge. I'm not heard one today. So there seems to be this underlying argument of delay, and Mr. Cochran's sort of allegations about conspiracy theories that I decided, frankly, it was unproductive for me. It cost my client money to actually go down this rabbit trail to say, okay, I'm just going to stick with in the 4 corners of the document. Here's the notices. Here's the time of it. We'll show up and we'll do the thing. So I made that decision.
Okay. I think those are the questions. Oh, I have one more question, Mr. Cochran. Why was the injunction sought only now at the 4th or 5th rescheduling as opposed to at the 1st or 2nd? Because the things that animate you and have animated your pleadings seem to have existed other than the number of times you or your client writes and don't get a response for the reasons I've now heard, that seems to be the only thing that's changed. So why is it so? Is it because the hospital has finally said, no, we're not rescheduling again? They said yes to your first 4 requests, but they finally said, enough. This is a date we're not going to move. And that's why you're seeking the injunction?
Your Honor, no. First of all, we wrote, let me say this. I would ask that you look at the exhibits that we have identified and the number of times we wrote very reasonable letters asking very reasonable questions and got no response. Now, in direct response to your question, what has changed? We had to, the last time we asked for a continuance, we had to threaten a lawsuit, and there's an exhibit in there that you'll read. It's near the end where they wouldn't respond to us. And we said, look, do we have to go to court to get a continuance because of COVID-19? That's just not reasonable. They finally gave us the continuance. The next thing that happens is they announce the hearing on April the 14th and then turn around the next day and they terminate him. They fire him. All right. And they put this footnote 1 in the letter, it's exhibit 20, and they invite a lawsuit. They say, we're going to terminate you for cause. But if you go to court and you convince a judge that it's we don't have the power to do that, then it's without cause. But either way, with cause or without cause, you're terminated. So the answer to the question is, why did we wait? It's because we got that letter on April the 15th terminating Dr. Randolph and tried to figure out, okay, what do we do now?
Okay. So I need to go back to Mr. Moldovan. I had a chance to look at 16A, which is a letter, it's an email from Dr. Randolph to the 3 doctors on the hearing panel where he's requesting a postponement, and he relies on President Trump for part of that. But he has some questions that are procedural, like video conferencing, will that be used, et cetera. It sounds like that didn't get a response. So it's not an email or letter from Mr. Cochran. I'm not saying Mr. Cochran didn't help Dr. Randolph write this, but it's an email from Dr. Randolph to the members of the hearing panel. And Mr. Cochran is saying that went unresponded to. Any reason other than what you've already shared why questions like, would we do this via video conferencing, why those wouldn't have been answered?
I can't hear him.
Oh, you may be on mute.
Sorry, my fault.
Yeah.
They granted the request for the postponement, and then the next letter from Mr. Watkins. And by the way, the CEO under the bylaws is required to send out the notices. That's why he sent them out, because the bylaws require it. Put in there, we'll do by video conference if necessary. So my understanding is they thought they had responded to that. And it's not a conspiracy, it's to hurt Dr. Randolph.
But there's an exhibit somewhere out there that is Mr. Watkins's notice that says we can do video conferencing if that's what folks want. That is subsequent to this March 31st email.
Okay.
I'm asking that. It's a question.
I don't know. I don't know the exact timing. I know that they felt that if they needed to do video conferencing, that was perfectly appropriate. And that's why Mr. Watkins put that into the letter, but because that was subsequent to that, it was a notice for this hearing.
Okay.
So April 17th or 18th, whenever they set the notice for the May 22nd hearing, 30 days prior, you put that in the letter saying we can do video conferencing if that's what we need to do.
Is that an exhibit?
It is an exhibit. It's in the material. So, Grant, can you find it? It would have been the notice for the hearing of May 22nd, and I can. Grant, you can find it.
Is it the No, that's the employment agreement termination.
It's our Exhibit 19, Your Honor.
We don't have it here, I can give it to you. I'm trying to find it, I'm shuffling around here, but there's a letter that was sent to you on May 22nd that had that line in that. In there.
Randolph Exhibit 19, Your Honor.
There it is. Randolph Exhibit 19.
Thank you, Mr. Cochran.
Yeah, if you look at the opening paragraph.
Okay. Mr. Cochran, anything more you want to share on behalf of your client?
No, Your Honor. Just please look at the exhibits.
There are a lot of them. Anyone in particular?
16A, 16B, 16C, 16D.
Okay. Well, I've already started down that trail. Mr. Blitch, anything else?
Oh, Your Honor, just thankful for the court's attention to this matter and having this hearing the way you've held it.
Happy to do it, and I'm glad we were able to accommodate everyone's different needs. Mr. Moldovan, anything on behalf of the hospital?
No, sir.
Mr. Kruger?
Thank you, sir.
All right. Well, Dr. Randolph, it was nice meeting you remotely like this, but you're in a safer place right there. I am sorry you've been going through what you've been going through. You are very well represented. Your lawyers have made the case they need to make on your behalf. Whatever the outcome is, I wish you the very best in your future endeavors. It sounds like they won't be in Noonan, but wherever you do end up, thank you for the good work you have done in the past on behalf of cancer patients. I have a brother who is not doing well, and he is off to MD Anderson tomorrow. So we'll all hold a thought for him and the practitioners like you and your colleagues mixed up in this case who are just trying to make folks well. So I appreciate your time in this matter.
Thank you for hearing the case. I'm sorry that all things didn't come out, but thank you.
Okay. Who is taking care of Ms. Williams? Splitting it? Okay, so you guys will make sure that's all handled. All right. Well, good. I need to get something out soon, so folks know what's going to happen over the next few days. I guess let me ask this, Mr. Moldovan, while everyone's still connected. You mentioned that Dr. Randolph had noticed that he may be calling a few experts for a hearing scheduled for Friday. So some steps have been made to prepare for that. And the concern you articulated is that if we move it to allow more careful planning for how people plug in remotely, et cetera, that given the crazy schedules that doctors have, if you ever tried to get a doctor to serve on a jury, good luck, that we may run into immovable objects because Dr. X or Dr. Y may not be able to step away from treatment to be at the hearing.
That's true, and our doctors as well.
Sure.
We have 3 practicing doctors on the hearing panel. There are some doctors who practice who may be witnesses at the hearing. They're all geared and ready to go. And the idea of trying to move this again would be, I think, would be unfair.
Okay. Mr. Cochran, you shared with me that you've been involved with a whole bunch of these peer review events. In your experience, how long does the hearing go?
Typically what happens is you have a session, you recess, you come back 3 weeks later, you have another session, you come back 3 weeks later, so that you accommodate the doctors. Now, one thing I would point out, where we were trying to accommodate all this and recognizing the problems with COVID-19, on Exhibit 10, Dr. Randolph's Exhibit 10, we asked way back in March, early March, about doing the depositions of the experts. And we use the depositions and then just play the video for the hearing committee, which would resolve a lot of these issues. That's something that we could talk about and would resolve all of these problems. And we've been trying to do that since March.
Okay.
No response to that request either.
Okay. I gather that. All right. But your experience is that the hearing is actually a series of hearings. It's not just in the course of a day or part of
Correct.
a day, the entire event occurs.
I've had them go 5 months where I would drive to Augusta, the Medical College of Georgia. We would start at 5 o'clock in the afternoon. You'd go till 11:30 or 1 o'clock in the morning. You'd recess. You'd come back 3 weeks later when it was convenient for all the doctors, and you'd do that again. And you would keep going until both sides had finished. I mean, that's very common. In fact, that's probably the rule rather than the exception. The exception would be to get it all done in one day or back-to-back days, because doctors just can't do back-to-back days.
Well, I'm glad I asked. So, Mr. Moldovan, do you have a different experience, or that is typically how it works? That really, if people convened on Friday the 22nd, that would be the beginning of a process that would not end on the 22nd, but that there would be a follow-up session?
It honestly depends. I've had it go both ways. I've some that have gone for 2 days and they go back to back sometimes. And frankly, sometimes we don't have a doctor committee. Some of the hospitals use a hearing officer who's a lawyer. And you have probably at least half the hospitals I've dealt with don't use doctors for a committee. This one does. So you have more flexibility with the hearing officer. But sometimes it's a day, sometimes it's a couple of days. I've never had anyone go 5 months. That seems like an outlier to me. So.
But you have had the experience that, in other words, it's not uncommon for the hearing to start on day one. People realize, well, we've been going for 4 hours and we're not going to finish. So let's agree on when day 2 would be. Sometimes day 2 is the very next day, but sometimes day 2 is 3 weeks later.
Yes, I've had that experience here. Of course, they've set aside the entire Friday. We've actually have it scheduled for them. We've blocked out their patients for that day, which again is why we're asking to get this done. That they would have devote the full day to that day. We have our doctors lined up for that day, again, to make them available for that day. We hope we could get it done, but it's possible.
Okay, got it. All right. Well, I have received lots of helpful information and argumentation from both sides. I'll just do one last pass through. Mr. Cochran, anything else on behalf of Dr. Randolph?
No, sir.
Mr. Blitch?
No, sir.
Okay. And Mr. Moldovan? Mr. Kruger?
Yes, sir. Thank you.
All right. Well, thank you, everyone. And thank you, Ms. Ward. I didn't mean to ignore you. I figured you would barge in if you needed to be involved.
I appreciate that, Your Honor.
All right. Take care, everyone.
Thank you, Your Honor.